What's up, guys? It's your boy, the Badwolf, coming at you from a different location. Got the office set up. Yay! All right, so this particular video is going to be about motions. Well, not emotions and not emotional or whatever. Court motions. What is a motion? Well, a motion is a particular act where you are, as they say here, a written or oral application requesting a court to make a specified ruling or order. All right, so once again, this is coming from Black Laws Edition, Dictionary Deluxe number 11. All right, I do recommend the expanded or deluxe version. So before we get started, I want to thank everybody for tuning in, supporting the Wolf, and, well, I guess just running with the pack. How about that? Whether you're in the front or the back, you got it like that. All right, so don't forget to hit that bell, like, subscribe, and don't forget to check out all the goodies down below. Scroll down on your phone for the consultations and the merchandise and files, whatever else you guys need. So that being said, let's get going. All right, so now that we told you a little bit about motions and what they are, a motion is a simple and formal request directed to a court. If your client needs something from a court, move or for it, you will be asking a judge to enter an order, okay? For example, and then it goes on to that. So there are a number of motions, and I'm going to see how far I can get. I'm not going to read all of them. I'm going to give you the ones I thought are fire, as always. Okay, so how are you guys doing? It's been a while. I feel like I haven't really reached out and talked to you guys. Doing good? All right. Oh, got some stuff going on? Sorry to hear about that. You too? Okay, cool. All right, appreciate you. Thank you for sharing. I feel like this brought us closer together. All right, so motion. Coram nobis motion. So CORAMNOBIS motion. 1944. A motion to vacate an allegedly unlawful conviction. Were you convicted of something you think was unlawful? Meaning, remember, legal means within the court. Lawful means on the Constitution. So is it something that the Constitution says you can do, but then they banged you on it? That sounds like an unlawful conviction to me. So you want to file a coram nobis motion. Okay, dilatory motion, DILATORY motion. 1. A motion made solely for the purpose of delaying or obstruction. A motion that delays the proceedings. So dilatory, okay, or like a dilation. So you can basically make a motion that you want to just delay the hearing or whatever you got going on. See, this is why you guys love me, because this is the good stuff. You can always tell the crazy in the eyes, right? All right. Just a madman in a box. Look at me, I'm in a box. All right, then. So, dispositive motion, 1939. A motion for a trial court order to decide a claim or case in favor of the movant without further proceedings specified. A motion that is, if granted, results in a judgment of the case as a whole, as with a motion for summary judgment or a motion to dismiss. So I believe that one is if you want the whole thing to be judged. Now, some people do. I think what we're talking about here is a summary where you want to be judged on just a piece of the situation, not the whole thing. Fire. Let's go. All right, so motion for reduction, 1973, family law. A motion to lessen the amount of child support payments. This is a type of motion to modify. Motion to modify, 1869, a post-final decree motion asking the court to change one of its earlier orders, especially a request to change child support or visitation. Also termed complaint for modification or a motion for modification. Omnibus motion, 1889, a motion that makes several requests or asks for multiple forms of relief. In criminal law, a defense pretrial motion requesting a hearing on various in limine motions as well as on suppression issues. Post-trial motion, a motion made after judgment is entered, such as a motion for a new trial. Show cause motion, a motion filed with the court requesting that a litigant be required to appear and explain why that litigant has failed to comply with a legal requirement. Okay, this motion is called a Rule 12b-6 motion. Rule 12b-6 motion. Okay, good. A motion to dismiss a case because the plaintiff has not stated a claim on which relief can be granted, often shortened to 12b-6 motion. See motion to dismiss. So if your plaintiff has not stated a claim on which relief can be made, that means, guys, everything you go through, you're not asking for relief or remedy. Can you move? This is kind of my moment to gloat, if you don't. Thanks. You're not asking for relief. You're not asking for remedy. Just those key words exactly is what you have to do. It's cool. You can come back over. Oh, your fur is so nice. All right. So, motion for a new trial. See motion for a new trial. Basically, you're telling them, I think we need a new trial. I feel like how this went down. All right. Motion for judgment notwithstanding the verdict. 1822. A party's request that the court entered a judgment in its favor despite the jury's contrary verdict because there is no legal sufficient evidentiary basis for the jury to find for the other party. Under the Federal Rule of Civil Procedures, another read, I think we did some of that in there, Federal Procedures, okay, this procedure has been replaced by the provision for a motion for judgment as a matter of law, which must be presented before the case has been submitted to the jury, but can be reasserted if it is denied and the jury returns an unfavorable verdict. Motion for judgment of acquittal, 1923. A criminal defendant request at the close of the government's case or the close of all evidence to be acquitted because there is no legal sufficient evidentiary basis on which a reasonable jury could return a guilty verdict. If the motion is granted, the government has no right of appeal. Motion for judgment on pleadings, 1923. A party's request that the court rule in favor based on the pleadings in the file, without accepting evidence, as when the outcome of the case rests on the court's interpretation of the law. That means they're not going in most of these situations, especially the lower courts, by cases that were already won, like such as the Supreme Court or the Federal District Court. They're going on their interpretation, feeling, like how some of these people reach out to me and how they feel a certain way. Don't really care, so I don't know why you email me. Just being honest, I don't really care how you feel when you don't like something I've done or said or whatever else. If you can prove that it was not accurate information, then send it to me in a nice manner. Unlike some people who want to reach out and be DICKs and then want to know why I'm not nicer to them because you were acting like a phallus. Okay? If you don't know what that is, look it up. Most of the guys should know what that is. All right. Motion for a rehearing, 1848. A party's request that the court allow another hearing of the case motion appeal, usually to consider an alleged error or omission in the court's judgment or opinion. Motion for relief judgment, 1867. A party's request that the court correct a clerical mistake in the judgment, that is a mistake that results in the judgment incorrectly reflecting the court's intentions, or relieve the party from the judgment because of such matters as a surprise, inexcusable neglect, something along those lines. Newly discovered evidence, lack of discovery. The judgment being the result of fraud, misrepresentation, misconduct by the party. Judgment being void. And or having been satisfied or released. How do you get a motion to satisfy or motion that something's been released? Interesting. All right. Motion in arrest of judgment. A defendant's motion claiming that the substantial error appearing on the face of the record vitiates the whole proceedings, meaning they found fraud or something else in there and should all be just done. And the judgment. A post-judgment motion in a criminal case claiming that the indictment is insufficient to sustain a judgment or that the verdict is somehow insufficient. Let's see what we got for time. Okay. Some of you guys have been asking me for a little bit longer videos. Well, I probably will never make an hour or half hour or anything like that, but 10 or 20 minutes, we're going to start doing a little bit more. You guys want more? I'm going to give you more. I feel like you guys want more me time, more face time. All right. Okay, so motion to compel discovery, 1860. A party's request that the court force the party's opponent to respond to a party's discovery request. Giving you guys gold here. This might even be gold pressed latinum, all right? To answer interrogatories or produce documents, often shortened form, motion to compel. Okay, fire, guys. Motion to dismiss, 18C. A request that the court dismisses the case because of settlement, voluntary withdrawal, or a procedural defect. Under the federal rules of civil procedure, a plaintiff may voluntarily dismiss the case under Rule 41A. Or the defendant may ask the court to dismiss the case, usually based on one of the defenses listed in Rule 12B. The defenses include lack of personal or subject matter jurisdiction. This is one of the things in my paper that we file, people. One of which, my paper is way more fire than just trying to use that one thing. Not that that's not a bad thing to use. They don't like my paperwork. That's what happens when you bother nice people, like a wolf. All right, so improper venue, insufficiency in the process, the plaintiff's failure to state a claim on which relief can be granted, the failure to join an indispensable party. A defendant will frequently file a motion to dismiss for failure to state a claim, which is governed by Rule 12b-6, claiming that even if the plaintiff's alleged or allegations are true, they would not be legally sufficient to state a claim on which relief can be granted. It's abbreviation MTD, see demure. Okay, motion to dismiss for failure to prosecute, 1889. Criminal procedure. A criminal defendant's motion, usually oral, made at the appointed time of trial if the prosecution cannot proceed, and when critical witness or crucial evidence is missing, typically proper only when a speedy trial deadline has passed. You have a right to speedy trial. One of my peoples was just like, who doesn't believe necessarily in this information, who's starting to learn, who's locked up right now in Huber, we'll leave that alone, but didn't want to listen to my advice or ask me how to do certain things. They kept postponing his trial. Guess what? You have a right to a speedy trial. If they deny you, right to a speedy trial. These are your rights. Could have got it squashed. Oh, wait, what is this? Motion to quash. That's kind of funny. 18C. I really got to see what these 18Cs and 1812, Rule 12B. I'm going to look that up. These sound like there's more fire information somewhere where I don't have a whole list of it, but we'll just move on for now. A party's request that the court nullify process or act instituted by the other party, as in seeking to nullify a subpoena. Motion to redact, 1973. A party's request that the court exclude certain parts of a document or recording and permit the party to obscure or remove those parts. A motion to redact is typically a form of a motion in limine, Limine. C, motion in limine. Okay. Motion to sever, civil procedure. Now remember, I told you guys to get those quick study charts. Go to quick study charts and Google that, and then find all this information, a lot more of it. If you're going to go to war, you got to have your weapons. Okay, because remember, according to them, trading with the Enemy Act, they're already at war with us. You guys are in it and don't even know it, and wondering why you get treated so bad. Why do you treat me? Sorry, I'm not going to sing. It's horrible. Okay. A party or defendant's request to have all or some of its claims or defenses tried separately from those of co-parties or co-defendants. You want to sever. Hey, I'm not trying to be, with all of them. Oh, but wait, there's more. Just like if sheriff, cop, tow truck company, courts, police officer all work together, that's RICO. You're all going to go down for that one. So, just got to give you guys some, loot in your boxes here. Motion to strike, 1806. Civil procedure. A party's request that the court delete insufficient defense or immaterial, redundant, impertinent, and scandalous statements from the opponent's pleadings. Motion to suppress, 18C. Criminal law. A request that the court prohibit the introduction of illegally obtained evidence at a criminal trial, termed suppression motion. Just like my same friend who they basically violated his rights, got some information, and used it against him. People don't want to listen to me until it's, go time, but it is what it is. Motion to transfer venue, 1934. A request that the court transfer the case to another district or county, usually because the original venue is improper under the applicable venue rules or because of local prejudice. Woo, woo, woo. There's one. Motion to transfer the venue. And if you're denied, go to the chief judge. Go up the ladder, people. Go up the ladder. I don't deal with low-level functionaries. No offense to those people it qualifies for. Motion to withdraw. The attorney may request, or whoever may request, for a court permission to cease representing a client in a lawsuit. A defendant's formal request for a court's permission to change the defendant's plea or strike an admission. All right. All right, so those are the main motions. Those are the top ones. Essentially, if there's something you want, you can say motion for this and then put down your description of what you want done and send it in. Now, there's a lot more. What time we got? 18? Okay. So I'll just go through a couple of motions. I'm just going to give you some names. You can look these up later. Hi, Lise. You can look these up if you want. Calendar motion, a motion relating to the time of the court appearance. Example, including motions to continue, motions to advance, motions to reset because of something in the calendar. Lots of good motions, guys. Contradictory motion, a motion that is likely to be contested or that non-moving side should have an opportunity to contest. Cross motion, enumerated motion, ex parte motion, a motion made to the court without notice to the adverse party, a motion that a court consider the rules on which hearing from all sides. Motion of course, speaking motion, special motion, coexistent motion, quasi-main motion, procedural motion, pending motion, motion for judgment as a matter of law. We'll read this one, and this will be the last one. Motion for judgment as a matter of law. 1956. A party's request that the court enter a judgment in its favor before the case is submitted to the jury or after the contrary jury verdict because there's no legally sufficient evidentiary basis on which the jury could find for the other party. Motion to lift and stay. No, this is for bankruptcy. I'll give you this one. Okay, so a party's request that the bankruptcy court alter the automatic bankruptcy stay to allow the movant to act against the debtor or the debtor's property, as when a creditor seeks permission to foreclose on a lien because its security interest is not adequately protected. Yeah. All right, guys. So that's it. Until and or unless I find some more fire gems in here, firestones. That will be it for sharing the information. Go get your own and go do your reading and put together your motions, your writs, and whatever else. So that's it. I want to thank you guys for staying this long, because I usually don't make videos this long, but I will be trying to do a live at least once a week. Or not once a week, excuse me, once a month. All right, everybody's been asking for that. Usually I pop on there. We do at least 1 hour to 3 hours. It's answering a lot of questions. So I apologize ahead of time if I can't get to yours. It's not personal. If I, kick you off, or I have one of my favorites, or my front of the pack wolves join, or whatever. It just is what it is. And also, guys, if you guys do happen to get my contact information, email, or whatever else on the personal side, remember, guys, I do have a personal side, personal life. So I cannot answer all those questions for free, and I've got a lot of people who are already in that circle. So please don't take it offensive. It's just I don't have the time nor the resources, and I don't want to be rude. So please don't make me have to block you or email, negatively or whatever. You get what I'm saying. Especially for those people who email me on like the days I'm off, or contact like an old business number or something like that, and they're like, oh, hey, I'm on doing the DS11, I'm number 11. How do you, especially on the weekends or at night, guys, I don't, the internet don't stop, but the wolf does. I need downtime. So, but to all the people who abide by all the simple and obvious levels of, 3 feet, man, privacy and whatever else, I appreciate you guys. Thank you for supporting. It does mean a lot to me. Thank you guys for joining the Wolf Pack. Those numbers are starting to look really good. So thank you, because that helps to keep the lights on and gives me time to, buy a nice plant and move my books into one spot and do this. So that's it. If you enjoyed the information, subscribe. Ladies, you guys have moved up to 27%. You guys are right behind the guys. So thank you. Guys, hope you guys don't mind being chased by the ladies. Or guys, girls, hey, chase each other. I don't care whatever you guys do. As long as there's permission and everything is, good, then do good. That is it. Have fun. Take care. Appreciate you guys. Oh, and thank you for the compliments, ladies and guys. I appreciate that. And that's it for now. Take care, and I'll talk to you guys later. Go get them.